The list that the ACC often refers to has never been peer-reviewed. It is not published. We cannot find those chemicals. What were found were initially TDCPP, which is chlorinated tris, which is a Prop 65 chemical. When we brought legal action against those companies, they switched. What did they switch to? Firemaster 550, which is a chemical that is now being looked at for reproductive harm and neurodevelopmental harm, obesity, heart defects, anxiety. These are not safe chemicals that are being switched to. Just because something is not on the Prop 65 list, there are only about 3 flame retardants, a very small number on the Prop 65 list. That does not mean the rest of them are safe.
Have these chemicals or these flame retardants been looked at and evaluated by the green chemistry, DTSC?
So DTSC has begun a slow process, and one of the product combinations they're looking at are children's sleeping products with one chemical, chlorinated tris. Because chlorinated tris was placed on the Prop 65 list, almost all manufacturers have ceased its production. And so what's happening is substitutes, like the one I just mentioned, the toxic shell game, where you switch a molecule, and now we have Firemaster 550. Now that that's being looked to be problematic, there's Firemaster 600. I'm sure there'll be 650 and 700 after that, and they're all in the same family.
Senator Mendoza, if I may, just want to suggest that it's a bit of an attempt to confuse the committee to throw in Prop 65 and green chemistry, because neither of them have anything to do with disclosure. If this bill were trying to ban a chemical or to say a chemical is dangerous before it's gone through the green chemistry process, that would be an appropriate comment. But this is just about disclosure. And with regard to Prop 65, it is specific to cancer and reproductive harm. These chemicals that we're talking about have a much broader health concern than just cancer or reproductive harm. And also the enforcement for Prop 65 is very different from what our bill is suggesting. Prop 65 enforcement is carried out through civil lawsuits, and the enforcement of this bill will be carried out by the Bureau of Home Furnishings. So they're completely different entities, and it's just an attempt to confuse.
One last question now. Why do you choose to put the label on all the products versus just the ones that do contain flame retardants?
So as has already been stated, it's almost insult to injury. Actually, insult to injury to insult, because we're talking about, number one, products that our infants and our youngest children have the most daily intimate contact with. They're going to school or daycare and putting their heads on them, they're napping on them for hours at a time potentially, so close contact. That's one assault. My
question was that why do you want to put this label both
Sure.
on the products that have it and the products that don't have it?
So secondly, the state has already determined that these are not fire risk products. So there's no need for flame retardants in them, but we know for testing that they still have flame retardants in them. So all this bill does is will let consumers know that they do or do not have. And so it's just about consumer choice. And if we knew that there was absolutely no use of these chemicals, maybe at some point we will know that, but we don't now.
Perhaps I could add
Go
something
ahead.
to that.
Briefly, please.
The reason for not just labeling those that have flame retardants is that the absence of a label does not give parents the affirmative statement they want, which is this product does not have flame retardants. So you see a product without a label, how is that person supposed to know that that means that's a good thing? Mr. Felon has suggested that we do a public education campaign to the 38 million Californians to let them know the absence of this label on a product means it's safe. That's not realistic. What we're providing is a simple label that a consumer can see that gives a positive affirmation of the safety of that product. I don't know if that answers your question, but
for me, I might create some sort of paranoia saying, well, what does have? We're going to be asking for labels on everything, or you know what I'm saying? Clothing. I mean, what's the labels going to start looking like?
I think that the work that has been done by the Center for Environmental Health on this issue, I applaud them, and I applaud the work that Senator Leno and his staff have done on this flame retardant issue, and we've been proud partners with them on this. They tested one class of products, and that was nap mats. Our association has requested those test studies. We have not received
That's
those
incorrect.
Please,
I provided
ma'am.
those.
You get to respond.
those test studies. I also feel as though this issue really needs to be fleshed out longer. We also tried to work with the office in having a label if products were intentionally added to have flame retardant. So you're having manufacturers still having to disclose. You're saying to them, if the product is intentionally adding flame retardant, you have to add this product, and that was not agreed upon. So we've tried to work through collaborating on this issue to get to language that we both can agree on. Our association is not opposed in any way to regulation or disclosing information when it makes sense, but in this case, these products are exempt and aren't required to have it, so they aren't doing it. So if they do add flame retardants, make them disclose it by doing that and creating that label that actually makes sense rather than a simple disclosure box for all manufacturers.
Thank you. Did you want to respond?
That's not correct. We did provide information to the Juvenile Product Manufacturing Association of the products. It's not just the Center for Environmental Health. It's also the State of Washington Department of Ecology that tested changing pads. So it's not just one chemical. The other thing is that the absence of a label, when you go to a thrift store and you pick up a product and you're a mom who wants to buy a product, how will you know whether that product is safe or not? You don't know that that product not having a label means it's safe. So I don't understand how this will help secondhand users or first users for that matter.
I think having the label that says it does have it, then okay, but having a label that says it doesn't have it, but just to let you know this stuff, that, it's might create a little bit more of a,
Senator,
I think it's necessary.
I'm sorry, Ms. Levin makes a really good point, which is a simple label will say it does have, it doesn't have. If a label just said it does have, and then you see something that doesn't have a label, and you didn't know that a product that did have the chemicals required the label, you wouldn't know anything was missing. You wouldn't know anything. And if you're concerned, if you are informed enough to at least have a concern about the chemicals, and you don't see a label, then again, you're without the information needed to make an informed choice. So I don't want to be disingenuous here, and it would be hard for me to do so. I've been fighting the chemical industry with regard to these chemicals for many years, and I don't want to leave out the concern of the firefighters. So this will allow for market choice, informed consumer choice. It's pretty obvious that some of the resistance here from the chemical industry is that they know that when consumers are informed and have a choice, they're probably going to choose without. This is just my supposition here. And over time, years from now, we'll have fewer products that are purchased with these chemicals, which means demand will fall, which means manufacturers will choose not to because the market is there for those without. And that benefits the safety of firefighters. San Francisco Department firefighters have created their own firefighter cancer foundation. Over 200 San Francisco firefighters in the past 10 years have died of cancers related to these chemicals because they convert to known carcinogens when they burn. And as you heard the captain testify, despite all of their protective gear, they're still dying at exponentially high rates. So the goal is over time to let the free market work, to see that demand for products with the chemicals falls, in which case there'll be fewer products made with them. And that will provide not only safety to the children we're trying to protect, the environment, as well as to the firefighters who continue to die of exponentially high rates of these cancers. So it's a win-win-win all around. And again, it's a very simple bill just to give consumers the information they need to make a choice.
Very good, thank you. I'll take that as your close, Senator Leno.
Ask for yours.
Sorry, Senator Berryhill.
Okay.
Quick comment, yeah, this seems like just a lot more government to me, and it seems to me, to the senator's point just now, if a company wants to put a label saying that these things are chemical-free, it seems to me like it's a possibility of a marketing opportunity, and anybody can do that. This forcing just more and more and more regulation on these companies is just death by 1,000 cuts. So for me, I've got concerns about this bill because I think companies have the ability to do this right now, and if that's the way they want to sell their products, I think it's a competitive edge. Thank you.
Senator, if I may just
Of
close,
course.
just to remind the committee that for over 30 years, the very products we're talking about here, these specific 21 products, juvenile products, were required to have a label that they complied with our fire safety standard. For 3 decades, 35 years in fact, they did it. It was no hardship. Their markets grew, our economy grew, California thrived. For the past so many months, they have not had to do a label. We're now suggesting this label should go on saying it has or has not. This is not onerous in any way. The prior label didn't harm them. The future label, as we're doing with upholstered furniture, will not cause them any harm, but it will protect our children in particular and our environment and our firefighters. I will ask for your aye vote.
Very good, thank you. Senator Leno, other questions? Seeing none? Yeah, I mean, in looking at this, I think it's appropriate to add the label and to bring it back. And the more I've thought about it, and the more with the testimony today, to me, the issue is erring on the side of safety and notification. And with the global market that we have, the global construction, manufacturing, and the legacy chemicals that may be in these certain mats here, but then they're applied. And as a product is constructed and put together, we don't know whether that piece may have some, it may be going to other parts of the world that required some flame retardant. And I think we want to make sure that the consumer in California has that protection. So I certainly will be supporting it. Is there a motion on the bill?
I'll move the bill.
Thank you. We have a motion from Senator Wojtkowski to do pass to the Environmental Quality Committee.
Hill?
Aye.
Hill, aye. Bates? Berryhill?
No.
Berryhill, no. Block? Galgiani? Hernandez?
Aye.
Hernandez, aye. Jackson? Mendoza? Wojtkowski?
Aye.
Wojtkowski, aye.
The bill has 3 votes. We'll place the bill on call.
Very good.
And we need 2 more, and we'll deal with it when we get back from session after we do one more bill for Senator Money. Thank you, Senator Leno.
Thank you, Mr. Chair and committee members.
Thank you all for the presentation.
That was the big one.
Senator Monning, we will.
Thank you, Mr. Chair, members.
Your bill is not controversial.
That's my understanding, and hopefully it'll stay that way. We're not aware of any opposition. I'll be very brief. This bill, SB 560, is part of our efforts on the underground economy to level the playing field. This is supported by the Contractor State Licensing Board that estimates that 20% of the time that a notice to appear in Superior Court is issued for failure to be licensed with a contractor's license, that same individual has failed to secure the required workers' compensation insurance as well. Though CSLB has the authority to issue a written notice to appear in Superior Court for unlicensed contractors under current law, it does not have the same authority to include charges for violating workers' comp insurance requirements. Specifically, SB 560 would expand the jurisdiction of CSLB's Enforcement Division to include ensuring payment for adequate workers' compensation in addition to the authority they currently have for licensing compliance, and streamline the referral of these cases to local district attorneys for prosecution. Mr. Chair, members, we've received no opposition to this measure. With the Chair's permission, I'd like to present Ms. Laura Zuniga from the Contractor State Licensing Board in support. Thank you.
Thank you. And there is no opposition, as you know.
Laura Zuniga with the Contractor State License Board in support. Would like to thank Senator Monning for carrying this legislation. It would allow us to issue a written notice to appear to unlicensed contractors who also fail to secure workers' compensation insurance. Thank you.
Thank you. Other witnesses in support?
Mr. Chair, Phil Vermeulen on behalf of the Flash Barricade Association of Fence Contractors in strong support. Urge your aye vote.
Very good. Thank you very much. Other witnesses in support? Seeing none. Witnesses in opposition? There's no opposition to the bill. Bringing it back to the committee. We have a motion from Senator Berryhill. Would you like to
Respectfully ask for an aye vote.
Thank you, Senator Monning. We have a motion to pass to appropriations. Please call the roll.
Hill?
Aye.
Hill, aye. Bates? Berryhill?
Aye.
Berryhill, I. Block.
Aye.
Block, I. Galgiani.
Aye.
Galgiani, I. Hernandez. Hernandez, I. Jackson. Mendoza.
Aye.
Mendoza, I. Wachowski. Wachowski, I.
7, that has 7 votes. The bill will be out, but we'll hold the roll open for the absent members. Thank you very much,
Mr.
Senator
Chair.
Lonnie.
Thank you, members.
For rushing through that. Appreciate it. We will take a recess until the Senate session is concluded, and then we will reconvene after that.
That's my favorite subject.
Okay, good afternoon again, everyone, and welcome back to the Senate Business and Professions and Economic Development Committee. We'll reconvene the hearing today, and we will begin with Senator Block, and we will do SB 620 first. That would be the of your 2 bills.